It's 3:30, so I'll get started. So hi, my name is Domenica Moran, and I'm an associate lawyer at Appiah Law. Our firm is a boutique employment and labor firm. My principal, Rich Appy, and I work together with both employees and with employers of all sizes who require assistance to support, motivate, and manage their workers. Okay, so I'm very eager and excited to speak with you all today about the employee's duty to accommodate in the context of the COVID-19 pandemic. So in the next half hour, I will be speaking about an employer's duty to accommodate an employee's family status. So just to give you a brief outline of today's discussion, first I will speak about the Ontario Human Rights Code and the scope of family status. Then I will discuss some unique challenges to accommodating family status due to the COVID-19 pandemic. And then finally, I'll close with some practical tips you can use to help your to help meet your business's obligations under the code. Okay, so as I'm sure many of you know, under the Ontario Human Rights Code, employers are required to accommodate workplace modifications that employees may require based on a number of protected grounds. You know, for instance, some of these grounds are things like age, race, ethnicity, gender, and sexual orientation, just to name a few examples. The protected ground that I will be speaking about today is family status. Family status captures the parent-child relationship and the employee's role as a caregiver to their children. It also captures an employee's role as a caregiver to their parents. Generally speaking, an accommodation request on the basis of family status can be something as simple as like an employee's babysitter canceled last minute and he needs to duck out of the office 30 minutes early to go pick up his kids from school. Other requests may require long-term modifications. For example, like an employee who needs to start work later on Tuesday mornings so she can drive her elderly mother to her weekly doctor's appointments. Those are some typical family status accommodation requests that maybe some of you are familiar with already. But I want to touch on family status and how it's been affected by COVID-19. As many of you know, the realities of COVID-19 have presented pretty new challenges to accommodating an employee's family status. As is the case for many people, as well as myself, during the first wave of the pandemic, a lot of employees have transitioned from the office to working from home. And back in the spring of this year, we also saw school and daycare closures across the entire province. So in that sense, employees as well as their employers suddenly had to juggle operating out of home offices and managing their childcare or caregiving obligations. A lot of employees may have requested adjustments to their schedule so they can balance their caregiving duties as a form of accommodation. And the unique challenges don't end there. Now, as most of you probably know, schools and daycares have reopened in Ontario, at least for the time being. But in-person school attendance is now optional, and some parents have decided that their children will learn remotely from home due to safety concerns. Parents making this decision may require modifications to their work duties, but employers may see that decision as a personal choice that doesn't trigger the duty to accommodate. So an interesting question arises from this. Must employers accommodate the caregiving responsibilities of employees who have chosen to keep their children at home due to COVID-19 concerns? These are all important questions that might impact your workplace. So let's talk about how you approach an accommodation request and discuss some of these scenarios that I posed to you in more detail. Okay, so I'm going to speak a little bit about how you accommodate. The law regarding what employees need to demonstrate in order to receive accommodation on the basis of family status is quite complex, actually. But it requires more from an employee than simply pointing out that they have children or elderly parents and they're working from home. Generally, employees must demonstrate to some degree that their obligation to provide care is engaged, and that other arrangements, like finding an alternative caregiver, are not feasible in the circumstances. So, for example, and this is specifically in the context of COVID-19, for example, employers likely will have an obligation to modify an employee's duties or location of work if, for example, an employee's child is staying home from school because the child or another family member in the household is ill or they're in self-isolation, or perhaps the child or another family member in the home is at a higher risk of infection or from suffering significant complications from COVID-19, or the child's school or daycare closes, such as due to a positive COVID-19 infection. And even though schools are reopened now, I mean, that could happen anytime. So these are all scenarios where accommodation would likely be required to avoid situations that would result in a real disadvantage to the parent-child relationship, or that force employees to choose between working and caring for their children or parents. So in those situations, it's pretty likely that you would have to accommodate that employee's modification to their work schedule request, or whatever they're requesting as an accommodation. So let's go back to that remote learning example I posed to you earlier. What are employer obligations in situations where employees keep their children home from school for no reason other than a general concern for the child's safety? So in this example, just to be clear, this is a situation where no one in the home or the child is at a higher risk of infection or suffering significant complications from COVID-19. The parents just want to keep them home because they're just generally concerned about their safety. Unfortunately, there is no clear answer to this question as of yet. I can say that in the past, general concerns that a child might become ill have not typically triggered an employer's duty to accommodate. It remains to be seen whether the contagious nature of COVID-19 and the potential impact that the virus may have on children, as well as other family members, changes this. The answer will become clearer only when the Ontario Human Rights Tribunal rules on the matter, but the tribunal has yet to do so. So we have to be a little patient about the outcome of that. But let's talk about some practical tips on how you can accommodate a workplace modification request. On this section, I can say that the Human Rights Tribunal has often interpreted the code, and they've suggested that employees must first explore alternate childcare arrangements before they request a workplace accommodation for their childcare responsibilities. So typically before there's a formal accommodation request, the employee should look to see if they can work it out themselves. Such arrangements might include hiring a babysitter or arranging for another family member to provide care. Having said that, though, thanks to COVID-19, remember that employees have to have a demonstrated need for accommodation, but they only have to explore reasonable alternatives. So for instance, due to COVID-19, it now may be unreasonable to expect an employee to bring a babysitter into the home where another member in the household is at a higher risk of infection or suffering severe complications from COVID-19. Also, financial circumstances may also cause an unreasonable burden to the employee in securing alternative arrangements. So, for example, it may be unreasonable to expect an employee earning minimum wage to pay for very costly childcare. So that's just step one, and some practical steps to step one. The employee should first explore reasonable arrangements first. And again, the key word is that they must be reasonable. When an employee has established a duty to accommodate, employers who receive such a request have to do two things in good faith. The first thing that they must do is to make efforts to understand the employee's accommodation needs and consider options to accommodate those needs. So an example of that, or just to say this in another way, the employer has to investigate what the problem is and what solutions they could come up with the employee to solve them. The second thing the employer must do is to implement the most appropriate accommodation reasonable to the point of undue hardship. So to give you some examples of some potential forms of accommodation, these may include allowing the employee to work from home, allowing the employee to work alternate or reduced hours, or allow them to take breaks during the workday to perform childcare or caregiving duties. Or another option is to allow employees to take leaves of absence from work. These are all possible forms of accommodation that can work. But most of all, employers have to be flexible. Always remember that the same solution will not work for every employee seeking accommodation. Okay, so that said, though, employers are not necessarily required to grant employees their preferred accommodation, and employees must be open to accepting a reasonable solution that satisfies their needs. So, for example, let's say there's an employee who needs to drive her children to school every Monday, Wednesday, and Friday at 8:45 a.m. Normally, her work mornings start at 8:30 a.m. So she requests that she starts those work mornings a bit later at 9:30 a.m. However, let's say the employee also requests she starts all of her work mornings at that later time because she prefers to have a consistent work schedule every day. That kind of an accommodation is not required to fulfill her childcare obligations. And so the employer would only be obligated to accommodate her late starts on the Monday, Wednesday, and Friday. Okay, so that's just an example of, just to remind employers as well as employees that the employer doesn't have to actually grant their preferred accommodation. They have to provide a reasonable solution that satisfies their needs. So another question that arises is, how far do you have to accommodate? And must employers accommodate every request? Under the code, employers must accommodate workplace modifications that employees may require based on their family status up to the point of undue hardship. An undue hardship will be established only if the required accommodation is unduly costly or unsafe to implement. Costs, as well as sources of outside funding, if they're available, and health and safety requirements are the only relevant considerations here. Things like business inconvenience, employee morale, and third-party preferences are not valid considerations when assessing whether an accommodation causes undue hardship. So decisions of Ontario's Human Rights Tribunal impose a very high burden on employers seeking to demonstrate that accommodation will cause them undue hardship. Basically, it's really hard to establish this. Every accommodation request is unique, and what will constitute undue hardship depends on the particular circumstances of the employer. So I'll give you an example of this. Let's say there's an employee who is supposed to start work at 8 a.m. and they request they change their start time to 9:30 so they can take their children to school in the morning. Let's say the employee is a single parent and was unable to work out any other solution to their issue. Such an accommodation request may not be possible for a small family-run business with legitimate economic concerns that prevent such an accommodation, and that may constitute an undue hardship for them. However, such an accommodation request may be perfectly reasonable for a large corporation with a lot of workers who can cover for the employee. I will remind you, though, that again, the standard of undue hardship is very, very high, and it's very difficult to establish. A small business will not be exempted from accommodating an employee just because it is small. The small business in this example, for instance, would still likely be required to try and hire another worker to cover the employee's shift. Only cost and health and safety requirements will be considered when assessing undue hardship. Okay, so just keep that in mind. Okay, so as a final point here, I also want to briefly discuss any additional obligations employers have under the Employment Standards Act when thinking of ways to fulfill their duty to accommodate. And just for convenience, I refer to the Employment Standards Act as the ESA. The ESA was recently amended to create infectious disease emergency leave. This is an unpaid job-protected leave for employees who need to be away from work to care for their children because of, but not limited to, school or daycare closures caused by COVID-19. Such a leave may also apply to employees who need to take time off work to care for other close family members due to COVID-19. So when thinking of ways to accommodate an employee and working with them to find a solution, providing an unpaid leave may be a possible course of action. So let's go back to that remote learning example. I mentioned before that it's not clear whether employers have a duty to accommodate an employee's choice to keep their children home from school due to general concerns of COVID-19, because the tribunal has yet to rule on the issue. I'll just point out to you that the Ministry of Labor's ESA Policy and Interpretation Guide suggests that employees who have chosen not to send their kids to school or daycare due to concerns of their safety, or that they would be exposed to COVID-19 can qualify for infectious disease emergency leave. Also, in its announcement extending the expiry of infectious disease emergency leave to January 2nd, 2021, the Ontario government indicated that employees who have chosen to keep their children home from school or daycare due to concerns about COVID-19 can qualify for this leave. However, I'll point out to you that neither the advice found in the ESA Policy and Interpretation Guide nor the advice of the Ontario government has the force of law, but it is persuasive in terms of setting out an employee's rights. So until the ESA is amended to state that infectious disease emergency leave is applicable to employees choosing to keep their children home from school, or until the Ontario Labour Relations Board makes a ruling as to whether that's the case, the applicability of the ESA will remain unclear. In the meantime, though, employers may want to consider accommodating employees making this request by placing them on infectious disease emergency leave. So just to briefly conclude our discussion on leaves, employers should also keep in mind that the ESA allows for other types of unpaid leaves, such as parental leave, family medical leave, and family caregiver leave. And these may be applicable to an employee's individual circumstances. Employers should also explore whether these other job-protected leaves of absence may be available to an employee who is seeking accommodation for caregiving purposes and keep it into consideration. So again, these ESA leaves may be a possible solution when accommodating an employee's request for their family status. Okay, so I talked about a lot of things today. I'm just going to leave you with some key takeaways that are important when approaching accommodation requests. So again, to just recap, family status captures the parent-child relationship and the employee's role as a caregiver to their children. It also covers the employee's role as a caregiver to their own parents. Okay, so generally speaking, employees must demonstrate to some degree that their obligation to provide care is engaged, and that other arrangements like finding another caregiver or hiring a babysitter are not feasible in the circumstances. Again, as I mentioned, due to COVID-19, perhaps like introducing new people into the home where a member is at a higher risk of infection may not be a reasonable arrangement. That said, employees must first try to explore reasonable alternate childcare arrangements before they request a workplace accommodation. Then, when a duty to accommodate has been established, employers who receive such requests for accommodation from the employee must do two things in good faith. The first is to make efforts to understand the employee's accommodation needs and consider options to accommodate those needs. Second, the employer must implement the most appropriate accommodation reasonable to the point of undue hardship. An undue hardship will be established only if the required accommodation is unduly costly or unsafe to implement. And I also remind you that every accommodation request is unique. There is no one-size-fits-all approach here. What will be reasonable accommodation for one employee may not be reasonable for another. And as well, what will constitute undue hardship for one employer may be different for another. What constitutes undue hardship depends on the particular circumstances of each employer. Okay. Finally, employers should keep in mind that the ESA allows for many unpaid leaves, such as infectious disease emergency leave, parental leave, family medical leave, and family caregiver leave. And these all may be applicable to an employee's individual circumstances. So at this point, I would pause for any questions that anyone may have. And if not, I do have a case study that we can chat about, or some other questions that I predict someone may ask. So I'll just pause for a minute to see if anyone posts any questions. And if not, I have a question that we can discuss together. Well, maybe whilst people are typing, a question that we can discuss, and a question that some people may have, is what if working from home isn't working? And how far does a combination have to go? So let's talk about an example where an employee has chosen to keep their child home out of school because of a general concern for their safety, but there's no increased risk to them going to school. So in this example, to be clear, the child and no one else in the home is at a higher risk of infection or of suffering severe consequences from COVID-19. So in this scenario, there isn't an additional reason to keep the child home other than a general concern for their safety. So the employee requested to work from home in order to care for their child, and the employer grants the request. However, the employee's performance starts to suffer. And so this becomes a difficult question. How do you deal with performance issues? And is there a duty to accommodate the employee in this scenario? So as I mentioned before, when there's a duty to accommodate, you have an obligation to alter the employee's workload so the accommodation can be granted. And that may mean changing or altering objectives so employees can meet their childcare and professional obligations. As I mentioned before, the case law isn't clear whether there's a duty to accommodate someone who opted to keep their child at home. But that doesn't mean you shouldn't look at the case from an accommodation perspective. If you want to be safe and to avoid any liability, I would approach the case as if there was an accommodation duty here. So if performance problems arise, the best course of action is to engage in the usual performance management process that you normally do. So, deliver feedback, deliver clear work expectations, and keep in mind that the Ontario Human Rights Tribunal may say there's an obligation to accommodate this scenario. If you want to avoid any potential liability here, then discussing and altering the employee's duties may be part of the coaching process to help them meet their professional and parental obligations. Having the employee agree to the duties they can perform is a good idea. Also, it's helpful to get to the root of the problem. Is the employee struggling to get a decent number of uninterrupted work time due to their childcare obligations? Is that why their work performance is suffering? If that's the case, then perhaps can their schedule be altered so they can perform their work while another family member is available to watch the children? These are all possible solutions that you can explore here. And again, to repeat, it's helpful to get to the root of the problem and see how you can adapt the accommodation to meet those needs. Okay, so in sum, because we don't know how the tribunal will rule, one approach is to operate as if there is a duty to accommodate to avoid any potential liability.
Hi, Domenica. I'm Rachel.
Hi there.
How are you?
I'm good, thanks. How are you?
Good. I came on to introduce you, but you had already started, so I apologize for that just at the beginning there.
No worries.
So thanks for being here initially. You do have one question, so I don't know if you have a minute to answer it. So Helen is asking, does time off have to be paid during the COVID positive case investigation? Our hourly employees are not paid if not here. Would they have to use vacation or personal days?
Yeah, so I would say look to what your policies are. If you don't offer, paid time off for COVID-19, it's perfectly fine to put them on a leave, or you can suggest that they use vacation time or personal paid days. I don't foresee a problem with that.